2025. We are back on the record in case number 687886. The motion in limine filed by counsel for the defendant was filed on October 15th of 2024. The response by the state was filed August 6th of this year, 2025. I should say state's brief in opposition. Additionally, on August 8th of 2025, a reply brief filed by counsel for the defendant was filed. We will address this motion in limine first, as it being the defense motion. Who would like to be heard on behalf of the defendant?
With respect to our motion in limine filed back in October of last year, this relates to matters occurring before the medical board. Your Honor, as stated in our motion, and I'd like to incorporate by reference all of our arguments in law and motion.
So incorporated.
Thank you. Your Honor, the matters before the medical board are simply not relevant to this case. What's happening before the medical board are pending allegations. There have been no hearings before the medical board. My client has not had any due process with respect to the allegations before the medical board. There are different standards that are employed at the medical board level that are not applicable here in criminal court. And violations of medical board rules, even if proven, do not equate to violations of criminal laws. And what the state is trying to do is have several little mini trials based on allegations only that are at the medical board level. That, as the court can imagine, can become out of control very quickly. The other allegations, the medical board matters, are not relevant here. There's been no findings as to any of the allegations on page 7 in the state's brief. The risk of any unfair prejudice to the defendant substantially outweighed any probative value this evidence might have. Your Honor, we're asking you to grant our motion on those grounds. Thank you. With respect to this motion in limine, this relates to testimonial hearsay. We're moving the court to preclude the state from presenting any evidence of testimonial hearsay from either of the alleged victims. I'd like to first address the testimonial hearsay statements by MC made to Ms. Tina at CCDFS. Your Honor, our position is, and the evidence clearly establishes, that these statements by MC to CCDFS were 100% for an investigative purpose and were not for any medical diagnosis and treatment. And what the state is arguing is that they fall under that hearsay exception and are therefore admissible as non-hearsay statements.
Well, fall under which exception?
The exception for medical diagnosis and treatment.
803.
803. 4. Correct. Your Honor, this statement was made to Tina at CCDFS 4 years after the alleged incident. The idea that this was for medical diagnosis and treatment 4 years later is absurd. Detective Finucane from Beechwood Police contacted MC's mother, who, according to her, the whole thing could have been a misunderstanding, but it was Detective Finucane who reaches out to her. Detective Finucane and a captain from Beechwood called her back then the same day, and their goal is to try and induce her to bring her son in to the Beechwood Police Department to make a statement. Those phone calls occurred on December 8th of 2023. Ultimately, MC and his mother were brought into CCDFS following Monday, December 11th, where they both made statements to CCDFS. However, Detective Finucane accompanied them to CCDFS. But not only that, prior to going to CCDFS, MC's mother, Elsie, I'll refer to her as Elsie, specifically told Detective Finucane and the Beechwood captain she did not want to have her son speak with CCDFS. She only wanted to talk to the police. The purpose of Detective Finucane reaching out to the mother, Elsie, wasn't so that he could get diagnosis and treatment or reach out to make sure that MC was safe and do a safety assessment 4 years later. It was because SE had made his allegations, and Beechwood was investigating Dr. Kriwinsky in the wake of SE making these allegations. A Jewish news article had come out about the allegations, and the next day, Detective Finucane calls the mother, Elsie. We really want you to bring in your son. And in her interview, the mother, Elsie, even talks about what they were saying to her to induce her to bring her son in to make a statement. And one of the things she relays is that the captain said, "We got to get this guy." That's investigative. They are looking to bring in MC to see if there's enough evidence to add a charge to Dr. Kriwinsky. They're not worried about, is MC safe? Does MC need counseling? Does he need medical diagnosis and treatment? Does he need medication? They don't, that's none of that. And then when they get to CCDFS on that Monday, the 11th, Detective Finucane is there. And Miss Tina interviews the mom first. And she tells the mother, she says, "I'm going to make sure I ask all the questions that the detectives want me to ask." And after she interviews the mom, she brings in MC to do an interview with MC. And she tells MC, she says, "The detective is here." And MC asks her, "Is he listening in?" He says, "Yes, he's listening in. He's monitoring." The other thing is, we know there's no obligation, legal or otherwise. I know there was reference to this in the state's brief about some kind of obligation legally, that they bring MC to speak with CCDFS first. We know that that's not the case, because if you look at SE spoke to Beechwood Police first, and then several days later went and talked to CCDFS. So that's just not the case. So Beechwood Police coordinated this. They said to Mom, "You can't just talk to us. You have to go talk to CCDFS." MC knew Detective Finucane was monitoring the interview. Detective Finucane had provided questions or information to Tina to ask MC. And the state wants the court to believe that the primary purpose of Tina's interview with MC was a, quote, child protection and safety assessment. That's preposterous. It's only after he tells Tina his entire story that she brings up something about counseling, to which MC replies, "No, I don't need counseling. It's not something that affects me really in my day-to-day life." They talk about also in their brief in response a situation that had occurred in 2022 when MC had made reference to this allegation to a psychologist. If any medical diagnosis and treatment statements were made, if any, it would have been then.
That was my question. Is the first statement made to CCDCFS, was that made in December of 2023?
Correct.
Were there any statements made by MC to the police, a SAE nurse, prior to December of 2023?
No.
Thank you.
Your Honor, our position, again, primary purpose was investigating. MC was 16 years old at the time. He hadn't seen Dr. Kriwinsky for 4 years. This was something that Tina knew because she had just talked to his mother. No safety assessment was required. Again, he knew Detective Finucane was there and listening, and he was telling Tina what to say. And the reason we know that, and I mean Detective Finucane was telling her what to say, was because she stopped the interview with MC and said, hey, let me go make sure that I asked all the detectives questions. She left the room, presumably met with Detective Finucane, and then came back in the room and asked some follow-up questions. I point to our case, Woods, State versus Woods, in our motion, and it's an 8th District case, and that case held that in that situation, a social worker and an officer had teamed up to conduct this interview of alleged child victim. That the officer was present during the interview, and that 8th District held these statements were complete testimonial hearsay. They didn't fall under that exception for medical diagnosis and treatment. It said that when the officer is present, it suggests that the interview with the social worker is subterfuge. It's subterfuge for information gathering and investigative purposes, and that it was not to address any ongoing emergency. That's exactly what happened here. That's exactly what happened. There's no ongoing emergency when 4 years later they induce and ask the mother, Elsie, to bring in her son to give an interview under police watch at CCDFS. No medical diagnosis was made, no treatment was rendered, there was no referrals made. But what the state wants to do is play the tape of MC making these allegations, not present him as a witness, and then try and rely on his statements to meet their burden on that charge, and without us being able to cross-examine him. That's testimonial hearsay at its finest, okay, Your Honor, and it's inadmissible and violates his rights under state and federal constitutions of confrontation. So I ask the court to grant our motion with respect to MC's statements to Ms. Tina.
Anything further on behalf of the defendant?
Nothing further.
I'm going to issue my decision tomorrow morning regarding the 2 motions in limine. There's some additional case law that I would like to review before I make my ruling. And we'll proceed tomorrow at 9 a.m. I'm going to go off the record. We are adjourned.